Good morning, Facebook world. I am Attorney Roy, Senior Attorney here at the Farrell Firm. Thank you for tuning in today to this live question and answer session. We will be answering all of your questions as they relate to family law, which includes custody, visitation, child support, divorce, adoptions, etc. So tell your friends to tune in now. Most people have inaccurate information when it comes to family law, and today we want to set the record straight for you. So you can start typing your questions now. I will start off with questions that we have received in our inbox over the last couple of weeks. And while you guys are letting your friends know to tune in, or as you are typing your questions below, I want to give you a little information about the firm and what we do here. The Farrell Firm is located in Metro Atlanta, and we have a focus on family law litigation. Here we strive to reach a level of excellence and believe that when a client chooses to do business with our firm, they are in for a life-changing experience. Our commitment platform is called the Farrell 4, our commitment to more. This platform is our commitment to supreme service, knowledge, quality, and results. Last week, we went live on our knowledge platform and gave you all the new information pertaining to the changes in the Georgia child support laws. This week, we are pushing our service and knowledge platform by providing you with the information you received today. Good morning, Melba. Thanks for tuning in. The information provided today is general information, and every situation is different and requires detailed discussion before giving legal advice. If you need to meet with a lawyer, you should call and schedule a consultation. So these are some questions that we've received in the last couple of weeks in our inbox, and I'm going to start taking those now. It says, my boyfriend pays support for his daughter, but the mom won't let him see the child. Help us, please. So I can't say this enough. Child support does not equal custody or visitation rights. Meaning, if there is no legitimation or there's no divorce decree outlining a custodial and or visitation schedule, then you are not entitled to visitation simply because you're paying child support. They are two separate actions. So if you were never married to the mother of your child and you are paying child support for that child, that does not entitle you to visitation, nor does being on the birth certificate entitle you to custody or visitation. Your name being on the birth certificate means absolutely nothing when it comes to custody and visitation in Georgia if you were not married to the mother at the time. The dad refuses to do visitation. Under the new law, can I get more child support? Absolutely. The child support worksheet takes into account a parenting schedule that most parents institute. So the standard visitation is every other weekend, alternating holidays, and some summertime visit. If that dad is not exercising regular visitation, then it takes more money for you to raise your children and provide support on the weekends, holidays, and summertime that dad should have the children. So under the new Georgia child support laws, you can ask for an upward deviation because dad is not doing the visitation he's ordered to do. My son lives with me now because mom left him, but money still comes out of my check for child support. Okay, so your son is living with you. There's a court order child support for you to pay support to mom. What you have to do is modify the custody action and the child support. So you file a petition to modify custody and child support. You let the court know that your son now lives with you and you are providing all of his care so that custody can be officially switched and that child support can be placed on mom to be paid to you instead of the other way around. I want to get divorced. How will our stuff be divided? So in Georgia, we are an equitable division property. We are an equitable distribution state, which means we're not 50-50 like some states. It is considered what is equitable to the parties based on different situations and circumstances. So for instance, there are 13 reasons you can get a divorce in Georgia. And let's say you're getting a divorce because of adultery. Sometimes the court could say that, but for your adultery, you wouldn't be getting a divorce. And the fair thing to do, what's equitable, is to let the wife or the husband, whoever was not the adulterer, keep more of the assets that were obtained during the marriage. Can I get child support suspended while the children are with me on vacations and breaks? No. As I previously stated, child support is calculated giving credit to the other parent's parenting time, whether it be standard or extended time, even during the summer. It's usually calculated within the child support worksheet. If you have your children all summer and you're still paying support all summer, you might want to consider doing a modification of child support. Good morning, Sean Daniels. Thanks for tuning in. I have a question from Brandy. My husband left me and moved to another state. He will not pay for the divorce. He will send money for our child. How can I get a divorce without paying for it myself? The only way to get a divorce without paying for it yourself is to do the divorce yourself. Because if you use an attorney, you're going to have to pay for it. And while we can request attorney fees from your husband, it's unlikely because he no longer lives here. The court doesn't really have jurisdiction over him. So if you file for divorce, you would need to file actually in the state where he resides. If you want to have the court decide things like custody and child support. So it's very important that you get in for a consultation to find out what routes you can take to get a divorce here in Georgia, or what you need to do to get a divorce in the state of his residence. Hannah, my friend legitimated his child and has a visitation schedule, but the mom will not let him see the kids. What can he do? Great question. He needs to file an action for contempt. Anytime either parent is not following the court order, it is imperative that you file a contempt action, and do not wait for them to be in contempt of the court order 3 or 4 or 5 times before filing your action. The sooner the better, because you build a track record and you show the court that this parent does not know how to co-parent. Therefore, once you have so many contempt actions, you could possibly ask the court to modify the custody or visitation schedule. So it's important that you assert your rights, use the court order to your benefit. If they're not being followed, file a contempt action. Contempts can always be filed in the court that issued the order, no matter where either party reside. That's very important. Can my ex keep my son from coming to see me because she said he is sick? We have a court order in place saying I get set visitation. No, a child being sick is not a legal reason why dad cannot exercise his visitation schedule. The courts believe that both parents are capable of taking care of their children when they're well and when they're sick. And a child being sick is going to happen. Every parent expects it. Every parent knows it. And so that should not be a reason why you cannot have visitation with your child. Like I said, file a contempt action, because if she does it this time, he or she may do it again next time and the next time, and it will become a cycle. Question from Stacy. If I need to move out of state for a job, am I only required to notify the non-custodial parent 30 days prior to the move in writing and then mailed, and also notify the court of my new address? So it really depends on what your order says, Stacy, on your notice requirement. Most times in Georgia, the court requires a 30 days notice to the non-custodial parent, and it requires that you provide your new address within that time frame. It doesn't have to be mail certified. If your formal way of communicating with your ex is text or email, you can give notice that way, as long as they are put on notice that you are moving prior to. Question from Oscar. Is custody decided by a judge or a jury? That is a great question. Although divorces can be in front of a jury trial, a jury does not decide custody. Only a judge can decide custody and actions for custody. Shatarika, I hope I said that right. Question. My ex has other child support cases, so I'm getting $20 per week for 2 kids. He owes over $3,000. What can I do? He also had guy's license suspended, but they haven't caught him yet. You can file a contempt action. If your child support case is going through child support services, then child support services is going to do what they normally do. They're going to suspend license. They can file a contempt action, but they also don't send the sheriff out to serve for that contempt action. So if they don't provide service through certified mail, if they send it back that it was undeliverable, then that's considered no service. You can go through a private attorney and file a contempt action for his lack of payment for child support and for his arrears. We can have a private process server serve him or her. We can have a sheriff serve him or her, and then get set for a court date. We do ask for incarceration a lot of times with a purge payment. Once that purge payment is paid, they can be released. And so it just depends on the arrears balance, his ability to pay, and those types of things. Question from Melanie White. How do I go about getting a divorce when my husband left me while I was pregnant and went to PA? I have no idea where he resides, and he has been gone for 6 years. So if you do not know where he lives, you can ask for a divorce in Georgia. Sorry, guys, I don't know what happened, but I was answering Melanie White's question. Her husband's been gone for 6 years. He's moved to PA. She doesn't know where he is. Here in Georgia, you can file for a divorce in your county of residence. If you don't know where your spouse is, the court can order the divorce here in Georgia if you serve by publication. However, the divorce will not include things like child support. He has to be served and put on notice and be sued in the county of his residence. So the best thing for you is to get divorced in Georgia, get custody of your child here in Georgia, and then go through child support services to see if they can locate him using his social security number, his name, his date of birth, to see if you can get child support that way. Otherwise, Georgia does not have jurisdiction over him, and therefore they can't order child support. Does it look better in a judge's eyes to be married when you are trying to get primary custody? I've been told I need to marry my living girlfriend because it will give me a better chance. Is this true? The courts generally do not look at spouses or live-in partners. It's really the standard in Georgia is what's in the best interest of the child. If you are a better parent, you have more stable schedule, stable home environment. I apologize. You've been on your job a long time. You have a close-knit relationship with your child. Those are the things that the court looks at. There are several factors in the statute that the judges can consider. Do you co-parent well? Do you encourage a relationship with both parents? And so there's a lot of different things that the statute cites for what is considered in the best interest of the child. Marrying your living girlfriend is not one of those things. Question from Jessica. My kid's dad is $30,000 in arrears. The only thing he says is he does not have a job. How can I get my payments and arrears balanced? They have transferred his case. Again, you can file an action for contempt through a private attorney and ask for incarceration until a purge payment is made. Not having a job does not negate a parent from paying child support, nor does it negate their responsibility to support their child. The law says that every able-bodied parent can earn at least minimum wage and therefore pay support for their children. So I most certainly would get a private action of contempt going, have him served, and let the judges take care of him. Question from Ms. Perez. I have my ex on child support. He stopped paying child support in March. I don't know where he's located. He travels. He might be in Mexico. What can I do? I have no information on him. Again, contempt would be the best route to go, but if you don't know where he is, or you don't know how to locate him, you could try hiring a private investigator, or you can try taking your court order to Child Support Services to see if they can locate him. Those are the only things that can be done if you don't know where he is and you can't find him. Unfortunately, you can't have a contempt action without him being personally served. So getting a location on him is imperative if you want the judge to take care of it. Question from Jose Longway. If I'm paying on my arrears and current obligation, can my license still get suspended? Usually, if you are on your payment schedule with your arrears and your current obligation, they will not suspend your license. If you fall behind with your original support order more than 30 days, then they can send notice to suspend your license. But anytime you get a notice like that, you can go down to the child support office. You can make an arrangement with them most times to keep your license and stay current on your payments so that they won't suspend it. Question from Yaya. If I've already done a home evaluation for the courts, can they keep requesting a home evaluation? It's a civil guardianship case and no defects agency is involved. I can't answer that question because I need more information. What type of guardianship is it? Is it a guardianship for your children or somebody else's kids? So Yaya, if you could give me a little bit more details, I could probably answer a little better for you. Question from Jason. Hello, as a step parent, what rights do I have if something were to happen to my wife who is primary physical custodian of our daughter? The bio dad is around but not completely involved in her life. Me and my wife have a son together, and if something happens to my wife, I would want my stepdaughter to live with us. So Jason, that is awesome. We commend you for that. However, as a step parent, you don't have any rights to your stepdaughter unless you adopt her. And you would have to go through the step parent adoption process. And within that process, you could ask the court to terminate the biological father or legal father's rights to that stepdaughter. But there is a high standard to meet when you're asking a court to terminate a biological and or legal parent's rights to a child. And so you should probably schedule a consultation with our office to see if you all could meet the requirements that the judge looks at in order to terminate their rights and do the adoption. We have done several step-parent adoptions here at our office. They have all been successful because once we vet the case and find out if you have a case that can go through it, usually we don't have any issues getting that adoption paper signed. Question from Antonio. Since the mother never worked and has been on government assistance since the childbirth, can I get full custody? And will my child support drop? Also, if she's bashing the father on Facebook, what can the dad do? Socioeconomic status does not mean that a parent is unfit or that the child is not in a good home. Her being on government assistance and not working is not to her detriment when it comes to parenting. However, if it is in the best interest of your child to be in your primary custody because you are working and you have a stable home and you can provide some stability and structure for your child, then most certainly I would ask the court to give you primary custody. There is a standard that has to be met. You can't just say, hey, I want primary custody because she's not working. There has to be something that triggers that, and that's within the Georgia statutes and guidelines. So I would advise you, Mr. Taylor, to come and do a consultation so we can see if you meet any of those elements to do a modification of custody. DNA test says he's not mine. How can I stay in his life without her coming after me? The only way you can stay in his life is if she allows it, since he's not your biological child or she's not your biological child. If she tries to put you on child support, it will not be established because the DNA test says he's not yours. So she can't come after you per se, but you also can't be a part of his life if she does not allow it. Is there a way to get a divorce without having to come to court? Yes. Oftentimes people can get an uncontested divorce, which means they come to a full agreement on all issues: custody, child support, division of property, marital assets, marital debts. And if that is the case, then we can file what is called a motion for judgment on the pleadings and ask the judge to sign the final decree incorporating the settlement agreement, child support, worksheet, and parenting plan, and neither party would have to appear in court. I have heard that if my ex modifies child support because my pay went up, that I have to pay her attorney's fees. Is this true? How do I avoid it? Do I need to file the modification on my own every time I get a raise to avoid paying the attorney's fees? So child support modifications are not granted simply because you get a raise. It has to be a certain amount of an increase in your income. And most raises each year don't amount to that requirement. So if you're getting a raise and you're getting $1 or $2 raise per year, that's not going to amount each year to a modification of child support. Now, if you get a raise, let's say a $10,000 raise in a year or $20,000 raise in a year, then that may warrant a modification. And the way to avoid paying attorney's fees is to get you an attorney, have them run the worksheet, and settle out of court on what the child support increase should be and how much it should be. Thank you for your answer. You're welcome, Jason. I'm glad you were tuning in. It's permanent guardianship for my child. It was illegally established, in my opinion, because I didn't agree. And the permanent guardianship was awarded to the paternal grandmother, but she breaks every rule in the court order. So if the court awarded permanent guardianship to the paternal grandmother, your consent is not needed. Your consent is only required on a temporary guardianship. I don't know where your case started or where it's at now, but you may want to come in for a consultation so we can look at your court order, look at the permanent guardianship, and give you some legal advice about what your options are at this point. If the father haven't worked because of a work injury and couldn't pay child support, what can he do? Usually if you're injured on the job, you receive workman's compensation or some form of short-term disability, long-term disability. You are still required to pay child support from those funds. If you receive unemployment or Social Security, you are still required to pay child support. There is nothing that's going to negate your responsibility as a parent to help support your child. Lisbeth, how often can child support be modified? My ex-husband is not legal, so he does not report taxes or what he earns. He claims to earn less than what he actually makes right now. How can his pay be verified? I only get $450 for 2 girls, and I know he makes more. You can do a private modification action through an attorney where discovery can be done. With the discovery, we can request bank records, credit card statements, anything regarding his finances. We can request it and do an analysis to see what he's actually making. When you go through child support services, they pull the Department of Labor records to see what each parent is making. And if your non-custodial parent is not W-2'd and they are 1099 or they're self-employed or they're paid under the table, they don't go beyond the Department of Labor to verify funds. So you would need to hire a private attorney to do a modification of child support so that the discovery process can ensue and find out what his real money is. Stacy, what is the procedure for the custodial parent moving out of state? The non-custodial parent is behind on child support and has missed several months of visitation. The procedure is going to be based on your parenting plan or your court order. So usually court orders say, you are required to give 30 days notice. If you are moving, once you give that 30 days notice, you have to provide your new address and then you move. Chantel, if the father stops supporting the child pending court date / divorce, I can afford to take care of the child care. Is it better to wait for back pay or do temporary child support? So the court does not order back child support. If you are in the middle of divorce and your spouse has stopped helping to contribute for the care of your children, I would suggest you requesting a temporary hearing to get temporary child support. Otherwise, you're not going to get any child support until the final order is issued, and it's going to go from that date or a date after that. They're not going to go back to when the divorce was filed. So I would definitely suggest asking for a temporary hearing so you can get temporary child support. Excuse me. How much is a consultation? I thought in permanent guardianship they had to establish. Our consultations are $150. That gives you an hour with one of the attorneys in our office. And if you're going to schedule a consultation, we advise that you bring any court documents related to your case or your child or your divorce that are going to be relevant to us giving legal advice to your questions. So the person I had a baby with has not been involved and would like to sign over rights, but has never legitimated anyway. What is the process for this? And if they can't get in touch with him, how does one proceed? So technically, if you guys weren't married and he has never legitimated your child, he doesn't have technical rights like custody rights or visitation rights. However, as the biological parent, he has certain rights that are given kind of silently. So if you ever got married and your spouse wanted to adopt your child, you would still have to go through the process of the step-parent adoption. And within that process, that step-parent in the court would terminate the biological father's rights as the biological father. I know that's probably confusing, but he doesn't have rights. He can't come take your child or visit your child without your permission. And there's no need to really terminate his rights unless you're trying to do an adoption. What is the step to get full custody of my child if the mother trying to keep me out of his life? Good question, Ashton. My advice would be to, if you have a court order for visitation, and there's a parenting schedule that she's not following, the first step would be to file a contempt action that she's not following the court order. If there is no custody arrangement or parenting time established and you were not married at the time, then if you live in Georgia, you need to legitimate through the courts and establish your custodial and visitation rights or parenting time. Because without a document saying that you have custody and parenting time, you're not entitled to any visitation. Your follow-up said the mother is unfit and not stable enough. Unfitness is not the standard in Georgia. The standard in Georgia is what's in the best interest of the child. And so a lot of people would say that other parents are unfit based on their standards, but the courts look at what's in the best interest of the child. Unfit is no longer the standard in Georgia. The signing over right termination stop child support. So you have to go through juvenile court to terminate any parent's rights. And sometimes the court will deny that parent terminating their rights. So if that child is receiving any state assistance, food stamps, Medicaid, peach care, anything like that, the court can say, no, we're not going to terminate parental rights because he needs to pay child support or she needs to pay child support. This child is receiving state assistance or anything of that nature. And it does not necessarily stop child support, but most times it would. It just depends on the circumstance. The easiest way to terminate someone's rights is through an adoption process. That gives a clean slate to both sides. All right, it looks like I have answered all the questions that have come in. I believe that I've answered all of your questions. If you need legal advice and want to discuss your case in detail, please give us a call and schedule a consultation. The consultations are $150 and last for 1 hour. We look forward to serving you. Enjoy the rest of your day. I have a few more questions that just popped in. I do have your question. I'm not going to post it. It's pretty long, but again, my recommendation to you is to schedule a consultation. That way we can get into the details and the specifics, because right now the questions and what you're giving me is very vague. I can't really give you a full answer, and I would need to see the court order that's currently in place. I pay child support for 3 children, and they're only giving them a certain amount, a pay period 3 ways, but do not add up to the amounts. So by federal law, child support services is only allowed to take a certain percentage out of your check for child support, but that does not mean that you are not obligated to pay the balance. So if your child support for 3 children, let's say it's $600 to make it an even number, and they only take out $400 a month for all 3 orders, it is your responsibility to send in the additional $200 per month to make sure you meet your obligation each month. All right, that is all for now. Again, if you would like to schedule a consultation, our number is down below. Again, my name is Jeffany Roy. I'm senior attorney here at the Farrell firm. Thank you guys for tuning in, and thank you for your awesome questions.